Everyone, I'm so pleased you were able to join us today. Little housekeeping before we get started. Please use the Q&A feature to ask questions, and those will start to populate, and we'll ask the questions at the end of the presentations. Don't use the chat feature or we won't be able to see it. Please use the Q&A feature. Also, the Supreme Court rules require us to ensure that attendees stay for the entire hour, so we will only submit names for those people that have stayed for the entire hour. If for some reason you bounce off and have to bounce back in, but you use a different sign-in, please let me know. I've had people bounce off and then sign in with their phones instead of their emails, and then I can't track it. So if for some reason you sign in under different credentials, email me and let me know, lori.nelson@law.utah.edu. So let's get started with today's presentation. So I'm pleased to welcome Professor RonNell Andersen, who is a professor at the University of Utah S.J. Quinney College of Law, and Jeffrey Hunt, who is a partner at Parr Brown. They're going to present to us for approximately 15 to 20 minutes each, after which we will open it up for questions. But don't wait to put your questions in the queue if you're really interested in a topic. All right, RonNell, Jeffrey, I'll hand it over to you.
Thanks, Lori. Hi, everyone, and welcome to today's webinar. As Lori noted in the materials that she sent out to everyone, we're focusing on Justice Thomas, the First Amendment and media freedoms. Justice Clarence Thomas, the longest serving justice of the U.S. Supreme Court, has in the last couple of years expressed some idiosyncratic views on some key First Amendment issues, and he's gained particular attention for staking out some bold new positions on the free speech treatment of both the press and social media. Jeff and I both think about this intersection between the media and the law for a living. And I just want to say what a total privilege it is to be hosting a discussion with him and learning from him today, because I've really long admired his work in this space. And we're going to use today's session to take a deeper dive into a couple of Justice Thomas's recent observations and doctrinal criticisms, considering their origins, the critiques of them, their place within the justice's wider jurisprudence, and their likelihood of gaining traction with the fuller court. I'll walk us through one of these high-profile incidents, and then Jeff will help us sort through a second, and then we want to make sure to leave some good time for questions and discussion with all of you. Okay, the first of these solo First Amendment proclamations from Justice Thomas is his newly asserted position that the court should perhaps overturn the watershed libel case of New York Times versus Sullivan. By way of reminder, Sullivan was decided nearly 60 years ago at the height of the civil rights movement, and it focused on the New York Times' publication of an ad from supporters of Martin Luther King Jr., who were criticizing police in Montgomery, Alabama, for their ongoing abuse of civil rights protesters. The overall assertions in this ad were true. The police were, in fact, mistreating peaceful protesters, but the ad contained several factual inaccuracies on details like the number of times Dr. King had been arrested and the particular song that the protesters sung and so forth. Sullivan was the police commissioner, and he had sued and won $500,000 from a Southern jury in a libel action. And he was one of many Southern officials who had used these defamation suits as really a calculated tool to suppress Northern papers that were drawing attention to civil rights issues. And the court 9-0 held that the speech tort of defamation has constitutional dimensions. This imposition of massive civil liability for speech criticizing elected public officials is inconsistent, they said, with the First Amendment's commitment to uninhibited, robust, and wide open debate on matters of public concern. So it announced as a First Amendment matter that folks like Sullivan, these elected officials, could not prevail in defamation suits merely by showing the publication of defamatory speech, but instead they'd bear the burden of proving falsity themselves and of showing that the statement was made with a false standard that we call actual malice. That is, that the newspaper published it knowing it was false or recklessly disregarding its truth. people holding or seeking public office. And later, the court extended this more broadly to all public figures, famous people. They know that their actions will be the target of sharp criticism, and they have the huge capacity for counter speech to correct the record, the court said. And so democracy, free speech, free press values demand that we not allow public figures as defendants to censor dialogue through libel suits. And what this means is that the states cannot constitutionally set up common law or statutory libel schemes that impose liability without fault. With or without, that is, they can't, they must have these tough standards for public figure plaintiffs who try to bring these kinds of cases. Okay, so the setting for Justice Thomas's critique of this precedent was a denial of certiorari a couple of years ago in which the court refused to hear the case of a woman named Catherine McKee, who had accused Bill Cosby of sexual assault and then sued Cosby for libel after she said his lawyer leaked a letter designed to damage her reputation. She had lost in the Court of Appeals after being deemed one of these public figures who could not show actual malice. Justice Thomas agreed that the court shouldn't take up the case. But in a 14-page concurrence in the denial of certiorari, he wrote to, quote, explain why in an appropriate case we should reconsider the precedents. And he launched a really detailed critique of Sullivan and its progeny, which make it, in his view, too hard for public officials and public figures to win libel suits. His argument was decidedly originalist in its approach, a hallmark for Thomas in a lot of areas. And it suggested that the First Amendment and those who drafted and ratified it did nothing to limit the authority of states to protect the reputations of their citizens and their leaders as they see fit. Indeed, he correctly noted that when the First Amendment was ratified, many states made it very easy to sue for libel in civil actions and to prosecute libel as a crime. Opinions of the court before Sullivan, he reminded us, pretty repeatedly listed libel as an unprotected First Amendment category. So of Sullivan, Justice Thomas said, quote, we did not begin meddling in this area until 1964, nearly 175 years after the First Amendment was ratified. The states are perfectly capable of striking an acceptable balance between encouraging robust public discourse and providing a meaningful remedy for reputational harm. So we should not, he wrote, quote, continue to reflexively apply this policy-driven approach to the Constitution. Instead, we should carefully examine the original meaning of the First and 14th Amendments. If the Constitution does not require public figures to satisfy an actual malice standard in state law defamation suits, then neither should we. Now, the broader context here may itself be notable, and part of the reason that this got the attention that it did. Thomas chose to make his anti-Sullivan stand in a case in which neither party had raised it, and in a case that was extremely high profile. It was the first Me Too case to reach the court, and it one involving claims that an accused man had retaliated by attempting to ruin the woman's reputation. It also emerged on the heels of confirmation hearings for Justice Kavanaugh, leading some commentators to note that Justice Thomas's own experience of being accused of sexual harassment by Anita Hill may make him especially sympathetic to accused public officials who feel unfairly hamstrung in responding to what they see as reputational assault. And he did take this position quite strongly in this dissent from denial or concurrence with denial. He said, the common law deemed libels against public officials to be, quote, if anything, more serious and injurious than ordinary libels, because, quote, the people may be deceived and reject the best citizens to their great injury. Now, Thomas's suggestion that we throw out Sullivan was written for himself alone. No other justice joined it or has joined it since. And it faced at least some pushback on a handful of grounds. The first and obvious one is the stare decisis question, which is significant. The case is longstanding, it's foundational. The court hesitates to make these sorts of about faces in the constitutional area. Second, the assertion that Sullivan was itself some kind of sudden sea change or an act of activism imposing heightened First Amendment burdens on some state speech tort plaintiffs is at least partially countered by the fact that Sullivan was quite literally the first time that the court had the opportunity to speak to the question. The First Amendment wasn't even incorporated or recognized as applicable against the states until Gitlow in 1925. Sullivan was absolutely the first time that the court had faced a record in which public officials were plainly exploiting the state common law of libel as plaintiffs to censor their critics. Third, and more to the point, free speech and free press is a realm in which scholars and jurists have really struggled in their efforts to make an originalist approach feel appropriate or useful. And this is a reality that Thomas's own, sometimes quite non-originalist free speech opinions, at least sometimes reflects. Every First Amendment professor has to spell out for students how our early history on free speech and press, they're buggy. In 1798, a Congress that was packed with people who had just written or ratified the First Amendment enacted the Sedition Act, making it a crime to publish false, scandalous, or malicious writings against the government. Madison hated this contradiction, but the courts did, in fact, imprison and fine newspaper editors for violating the act. We have a history, an initial history of punishing people for speaking ill of the government, and then we turned our backs on it pretty significantly. It was not until the 1900s that Oliver Wendell Holmes gave birth to the modern First Amendment, in which he all but acknowledged he was sort of rejecting some of the founders' original views of the meaning of the text. So the question of sort of what point in time our First Amendment foundations begin is muddy for some. And the Sullivan opinion itself was deemed by many scholars and commentators to be originalist in that kind of wider sense, that it describes how efforts of public officials to weaponize libel law are problematic in the exact same way that our seditious libel history is. So the suggestion that we return to our originalist roots on this is a really complicated one. Finally, Justice Thomas faces serious practical pushback from concerned practitioners and scholars who say there is, in fact, voluminous evidence that the states cannot, in fact, be trusted to craft and enforce their own libel laws in speech and press protective ways without First Amendment limitations. Sullivan's fact pattern was evidence of the ways that officials could and would silence critics of official conduct from voicing their criticism, even though the criticism was believed to be true by those press publishers, and even though it is in fact true, because of doubt about whether it could be proven in court or fear of the expense of having to do so. Now, despite these complexities, Justice Thomas's new view on Sullivan is really thought-provoking and is having some noticeable impact in some potentially important ways. One is among academics, which I'll acknowledge some of y'all think is not a useful measure of real impact, but still, symposia, colloquia, blogs, law review articles, and the like are now having this conversation, centered on the ongoing viability of Sullivan. Thomas has blessed the inquiry and has spurred both support and critique on something that was, I assure you, previously regarded as entirely settled. If you told me 5 years ago that I would today be receiving the number of invitations that I now get to debate this principle of whether the watershed press freedom precedent should remain on the books, I really would have laughed in your face, but it is now happening. More concretely, key members of the National Defamation plaintiffs bar are now smartly, strategically considering cases that might present the opportunity to argue this principle. And a lone statement like this can be seen as an invitation for lower court judges and litigators to start challenging the standard more directly. And let's be clear here, there certainly is no shortage of historical examples of First Amendment dissents that migrate into majorities as tides shift. Now, things are complicated here because the Roberts Court has actually made aggressive First Amendment protection a centerpiece of its ongoing docket. And so whether they buy into this more broadly is a real question mark. Whether other conservatives could end up with Thomas on this, I think definitely remains to be seen. Justice Gorsuch was actually asked directly about Sullivan by a senator at his confirmation hearings. And although he was less direct about some other precedent questions, his answer on Sullivan was completely solid and supportive. Justice Kavanaugh's record at the DC Circuit seemed to suggest that he thinks Sullivan is good law and rightly decided. The predictions here are made even more complicated by the fact that in other First Amendment contexts, Thomas himself has joined the court's conservatives in reinvigorating free speech doctrine as sort of a large-scale deregulatory tool, applying it to things like public sector unions and campaign finance and content-based sign ordinances and commercial speech and mandated disclosures by crisis pregnancy centers, a lot of contexts in which the originalist inquiry wasn't employed, and in which the outcome might well have been incomprehensible to the framers, but is argued to be consistent with wider principles of modern First Amendment jurisprudence. So the tension over when we embrace First Amendment originalism is going to be sticky. Maybe the greatest impact of Thomas's anti-Sullivan argument is what I would sort of label a like tenor of the times impact. The way it maybe weakens Sullivan's spirit, the spirit of Sullivan, and press freedom's foundational status, even if Sullivan does remain good law. Three quick closing points to make on this front. The first is that Thomas's views here really situate themselves within, and I think reflect, the current anti-journalistic, anti-media mood in at least some circles. This comes as at a moment of deepening public distrust of the news media and more vitriol in that area than we've seen in a long while. And this is a shift that is surely attributable to a lot of factors, including the actions of the media itself, but it's still really notable for the way that it's bleeding in to judicial depictions where we've not seen it before. Just over a month ago, Judge Lawrence Silberman on the DC Circuit echoed the call to overrule Sullivan, repeating Justice Thomas's originalist claims, but adding to it a really stark charge that this protection is no longer deserved because in his view, almost every media organization in the country is biased in its reporting against the Republican Party. A judicial opinion that has itself sparked a firestorm of debate and spawned pushback from others, including former conservative Judge Michael Ludig, who called the Silberman opinion dangerous. Second, and I think this is super important, we are also at a moment where Sullivan principles are in the spotlight in some of the highest profile defamation suits against major media organizations since Sullivan itself. Staggeringly large, multi-billion with a B, billion-dollar suits have recently been filed against cable news networks Fox News and Newsmax by two voting machine companies, Dominion and Smartmatic, claiming the repeated dissemination of false and defamatory information about them on some of the company's major programming. And a central theme of these media companies' responses have been that the voting machine companies are public figures and that the news organizations were reporting on matters of public concern rooted in news gathering, newsworthy controversies that were raised by some segments of the population about the 2020 election, such that even if some portion of the information shared was false, it carries First Amendment protection. So we're in Sullivan territory on these big key cases. Third, and the details of this are well beyond our scope, I do think that Justice Thomas has at a minimum tapped into an already vibrant, really important, truly complicated debate about who exactly ought to be a public figure in our modern media climate, and especially the so-called limited purpose public figure doctrine, which can sometimes apply stringent actual malice standards to people whose fame or notoriety came about through, for example, high-profile victimhood, like in McKee, or going viral on social media, or otherwise drawing attention in our increasingly interconnected world. Okay, so all of this is to say that while at the moment, I would say there is no meaningful movement for Thomas's singular attack on Sullivan to actually take doctrinal root at the Supreme Court, it isn't without effect. I expect that he has altered the wider dynamics and the conversations on the scope of First Amendment protection in defamation actions and in press cases for some time to come. And I think that we will continue having conversations that maybe we didn't expect to have about Sullivan's ongoing vitality. Let me pass the baton now to Jeff, who can help us think about a second context in which Justice Thomas's solo views on a media matter are making First Amendment waves.
Thank you, RonNell. Thank you, Lori, for the invitation to appear on this webinar. And RonNell, that was just a superb summary of Sullivan and Justice Thomas's views and where those are leading other courts to perhaps reconsider the rationale for Sullivan. And I just like to say it's a pleasure to appear with you on this panel. I see RonNell every year at a media law conference that I attend in New York City, which is primarily for media lawyers in the defense bar, lawyers who are defending the media against defamation claims. And RonNell is a regular panelist at that seminar and has been for several years. So that just gives you an idea of the national stature that she has on these issues. So she's widely recognized. I'm just a toiler in the field. She's an expert in the field. So I'm going to talk a little bit about Justice Thomas and his views on social media, which were recently ventilated in another interesting concurring opinion that he wrote in a case where the case was dismissed, but Justice Thomas went on one of these riffs on issues that weren't really presented, weren't live issues, but he had some things to say. And so just a little background about the Trump Twitter case. This was a lawsuit filed in 2017 by 7 social media users who were blocked from accessing President Trump's Twitter account because they criticized the president or his policies. You might remember this got a lot of national media attention when the lawsuit was filed. The plaintiffs contended that blocking their accounts violated the First Amendment. The district court found that the interactive space on Twitter, which allowed users to view the comments of a poster and then comment on those, was a public forum, and that excluding the plaintiffs from this interactive space was unconstitutional viewpoint discrimination. In 2019, the Second Circuit affirmed the holding that the Twitter space was a public forum and that President Trump violated the First Amendment by blocking Twitter users because he disagreed with their views. Last year in 2020, the Trump administration filed a cert petition asking the United States Supreme Court to review the case. And they had 2 principal arguments. They argued that although President Trump used Twitter in an official capacity, in fact, some of his cabinet members found out that they were fired only by the fact that he tweeted it. That's how they found out the news. He also used it as a private citizen when he was blocking users. That was the argument, that, okay, I use it in my official capacity, that's true, but it doesn't mean I have to put up with what these people are saying about me, these nasty things. And when I block them, that's in my private capacity. Not a very persuasive argument in my view, but that was one of the hooks that they used to try to get the Supreme Court to accept cert. The other argument was that if the Second Circuit's ruling were affirmed, then the ability of public officials to insulate their social media accounts from all kinds of harassment, trolling, hate speech would be unfairly limited. And so that one, it's not that persuasive to me either, because most of the courts that have looked at these issues, the lower courts, have drawn a distinction between an official social media account that a government official uses to conduct and transact the public's business, and then private social media accounts that they use to communicate with their family and friends. The latter have held not to be public forums, and the former generally have held to be public forums. And when you're in, a public forum, you can be the subject of a lot of nasty speech. And as we've seen in some of these public forums that Mitt Romney has held, even at the state Republican convention, he was the subject of some nasty attacks. And that goes along with the territory of being a public official. The plaintiffs who won in the Second Circuit urged the court to stay out of the dispute. They said that the Second Circuit applied well settled precedent, concluding that President Trump's actions violated the First Amendment. The second argument that they made was that the president's Twitter account clearly functioned as an official source of news and information about the government and as a forum for speech by, to, and about the president. And that by blocking speakers with whom he disagreed, that was classic viewpoint discrimination that's prohibited by the First Amendment. And the last argument that the respondents made, urging the court not to accept the case, was that the decision would not conflict with any other Court of Appeals decision, which is a relevant factor for the court when deciding to accept cert on a case. Fast forward to January of 2021, and the Trump administration urged the court to dismiss the lawsuit as moot because he was sued in his official capacity as president. And once Joe Biden became president, he wouldn't have control over that account. So the case was moot. Kind of a curious position to take in light of his claim that he actually won the election. But that's the argument that his lawyers were making in urging the court to dismiss the lawsuit. And the Supreme Court agreed. I'm sure that they were relieved not to have to wade into that entire thicket, and vacated the Second Circuit's opinion and remanded the case to the Second Circuit with instructions to dismiss the case as moot. So that was all pretty garden variety Supreme Court jurisprudence in terms of looking at whether a case is moot or not. That took about one paragraph of the court's decision. And then Justice Thomas filed a 12-page concurring opinion in which he concurred in the dismissal of the case, but he went on this riff about issues that were not briefed by the parties, were not argued below, were not decided below, but were important to Justice Thomas because he had some things to say about the Second Circuit's opinion, and really about how these new social media platforms work and whether the traditional legal rules and First Amendment rules should be adjusted or applied in a different way to social media platforms, or if not, whether legislators should consider regulating these platforms in a way that prevents them from so-called censoring speakers because they may disagree with their views. So Justice Thomas starts out this concurring opinion by saying he agrees with the decision, but stressed that the case, quote, highlights the principal difficulty that surrounds digital platforms, namely that applying old doctrines to new digital platforms is rarely straightforward. Then he notes that the digital platforms controlled by Facebook, Twitter, and Google place an unprecedented amount of power over the control of speech in the hands of a few private companies, and who retain the power to exclude speakers from those platforms or to just eliminate the platforms altogether. And he writes that, quote, we will soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructure such as digital platforms. But he agreed that the Trump case was not the case to do that. Then in the next 12 pages, he does exactly that. He takes it all on in a free-form style and repeatedly considers a number of issues, as I said, that were not raised or decided below. And the first thing that he takes on is this idea that Twitter was a public forum. And he questions whether that was the case because it's privately owned, and Twitter retained unfettered authority to shut down that forum or kick users off it. So how could it be a public forum if Trump blocked certain users when Twitter could block all users, including President Trump, which it did, kicked Trump off of Twitter following the January 6th insurrection. The problem with that is that, as the Second Circuit pointed out, the government doesn't have to own the property or the forum or have complete control over it for it to be a public forum. If you think about it, that makes sense. It has to have temporary control. But when the government rents out a movie theater or a conference room at a hotel, it signs a contract with the hotel or the theater that allows the theater to terminate the contract. That doesn't mean that the government doesn't have control of that space during the time that it leased it. And so, it doesn't, whether a space or a property is a public forum doesn't necessarily turn on ownership or complete control. But that sort of was the pivot point for Justice Thomas to launch into this issue about control of these digital platforms. And once you frame the problem as one of concentrated private control over online platforms and the ability to exclude speakers from that platforms, then you start thinking about, okay, what are the legal ways that we can prevent those powerful companies from censoring speakers or kicking them off the platforms? And Justice Thomas offers up two solutions in his concurring opinion in the form of legal doctrines that have been applied in other contexts. And those two solutions are common carriage and public accommodations laws. And Justice Thomas writes, quote, "There's a fair argument that some digital platforms are sufficiently similar to common carriers or places of accommodation that they should be regulated as such." And I'd like to take those two in turn and then talk a little bit about where he's going with all of this. Common carriers, his argument there in the concurring opinion was that digital platforms at bottom are communication networks that carry messages from one user to another, just like a telephone or telegraph. And just like telephone companies and telegraph companies in the past, they can be regulated as common carriers. So, and also like utilities, these digital companies have enormous market dominance. They dominate the markets there are, therefore there are reasons to treat them like common carriers or utilities. And if that analogy is correct, then the remedy for blocked platform users would be for legislators to enact laws that restrict the right of the digital platform, Twitter, Facebook, whoever, to exclude users. Now, of course, in the Twitter case, there was no such law, so there's no reason to be talking about such a law, but that didn't stop Justice Thomas. He wanted to throw that out there. On public accommodations, the company is ordinarily a place of public accommodation. It provides lodging, food, entertainment, or other services to the general public. And so the idea being that if you hold yourself out to the public for the sales, for the sale of goods and services, you need to take all comers, generally speaking. And Twitter and other digital platforms resemble that definition, and therefore could be subject to regulations that limit their right to remove accounts, which would include government accounts, which would strengthen the argument that the space is government controlled because there would be restrictions on the ability of the platforms to remove government speech. So that was the public accommodations part of his concurring opinion. And he concludes really with a call to state legislatures to look at enacting laws regulating digital platforms because of their similarities to common carriers or to places of public accommodations. Why did Justice Thomas do this? Why would he go on for 12 pages talking about issues that weren't raised by the parties and that weren't before him? And RonNell's the expert in this area, but just from an amateur view of reading his concurring and dissenting opinions, he likes to use his concurrences and dissents to plant seeds to see if they'll grow. And he's doing it now with the Second Amendment cases since Heller. The Supreme Court has shown a reluctance to grant cert on cases that raise the issue of how far Heller goes. And he has filed some concurrences or dissents criticizing the court for not taking up a new gun case. I think he said that the court is treating the Second Amendment as a disfavored amendment. So I think that's one example that's similar to what he's doing here in the concurrence in the Trump Twitter case. I think he's doing the same thing in the McGee case and inviting the court to reconsider Sullivan. And he's sitting back, he's sort of throwing it out there and seeing if the seed germinates and see what the plaintiff's lawyers do with it, see if the lower courts maybe apply the Sullivan actual malice standard in a less strict way, which is something that I've seen happen in practice, that when it comes to knowing falsity or the reckless disregard, whether the media defendant entertained serious doubts about whether it was true or false, what quantum of evidence, is necessary to go to a jury on that. I think we're seeing, as a result of Justice Thomas's sort of hollowing out or trying to hollow out the rationale for Sullivan, courts starting to think maybe that quantum should be a little lower, and we should allow more of these cases to go to trial on actual malice. I think you're seeing that in the Sarah Palin case in New York, where she sued the New York Times. Plaintiffs' lawyers have raised Justice Thomas's argument that Sullivan should be overruled. They're laying the groundwork for preserving that issue for a Supreme Court appeal. So that's one thing I think that he's doing. Another thing I think is that his critique of the social media platforms reflects a broader view of conservatives that social media platforms are biased against the right, that they censor the views of the right disproportionately compared to the views of the left. And I think that this feeling accelerated in the wake of January 6th, after Twitter banned Trump from its platform. So I think there's some of that you could sense in this concurring opinion. And so where is all this heading? I think it's already heading there. I mean, just this last legislative session, you've seen a number of state legislatures considering bills that would regulate social media platforms, and those are working their way through the state legislatures. Some of those are going to get enacted, and I think that those battles are going to move to the court about whether laws that regulate social media in the way that Justice Thomas is advocating are constitutional or not. And we saw this just here in Utah this last legislative session with a bill called SB 228, which would have required social media companies to make more full disclosure of their moderation policies and give Utah residents or Utah companies, corporations, the right to appeal from being banned or having your voice limited on these social media platforms. That bill was passed by the legislature, the Senate and the House, but it was vetoed by Governor Cox, who had some concerns about the constitutionality. So, I think that this is just the beginning of this debate, particularly on the social media front. I think we're going to see courts considering these issues. And for me as a practitioner, what concerns me is if you sort of follow the logic that treating these social media companies as common carriers or places of public accommodation, and they can't pick and choose whose voices should be heard on those platforms through enforcing their terms of service. If you accept that premise, then that means that they can't kick the government off either. And so what that means is that you could have a social media company that would be forced to carry the statements of the government with respect to whatever policies are at issue, and it could be policies that they disagree with. So that raises, a compelled speech problem. It also kind of reeks of propaganda, sort of, annexing these private companies as a propaganda arm for the government. Just strikes me as a very dangerous thing and antithetical to the First Amendment. So that kind of concludes my summary of Justice Thomas's foray into the social media area. I mean, one thing about him, he's provocative. He stirs a lot of debate. RonNell's talking about these academic conferences in the practitioner seminars that I go to. That's what we're talking about. We're talking about Justice Thomas and his latest concurring opinion, whether it's about Sullivan or the Twitter case. So it's spurred a lot of discussion and some concern, at least among folks who are very speech protective and particularly who represent media defendants.
Okay, Lori, do you want to summarize for us questions that might be posted?
Yep. So the first question we have is, if they overrule Sullivan, won't it impact private citizens? Because at the present time, private citizens are targeted by powerful public figures. And won't overruling Sullivan impact private citizens' speech?
Yeah, no, I think that is a really important question and comment. I mean, part of the angle that Jeff and I took here was sort of to focus on the common theme in the space in which we work, which is I'm thinking about media defendants and social media defendants. But Sullivan is definitely not limited to situations in which the alleged libel occurred at the hands of a media organization. And in fact, the central premise of it is the right of individual citizens to have robust dialogue about the performance of people who are enacted in their name, who are carrying out the government at their behest. That Sullivan was the police commissioner. He was an elected police commissioner, and people who wanted to have conversations about Sullivan's performance in that job ought to, as a sort of core principle of democracy, have the free speech ability to do so. And the way that we effectuate that is by making sure that Sullivan can't take retaliatory action against them through the tool of defamation law. So I think that's absolutely right. And the wider point is that attacks on Sullivan both things are simultaneously true. Attacks on Sullivan, the watering down of, or certainly the elimination of the constitutional standards set forth by the court in Sullivan, would have a massive impact on news gatherers and publishers, media publishers. But it would also have a massive impact on the potentiality of lawsuits against any citizen who said, in the course of critiquing their government, said arguably false and defamatory things, even in minor ways, right? That's the sort of premise of Sullivan, and would no longer be buffered by this standard that is set forth in Sullivan and its progeny. Jeff, did you have thoughts on that? Did you want to chime in?
Those are excellent comments. I just have two additional thoughts. One is, I think there's some irony in the attacks on Sullivan by President Trump, who talked about loosening up the libel laws, and Rudy Giuliani now getting sued by Dominion, and Sidney Powell getting sued by Dominion and Smartmatic. They were all on the side of pounding the media and viewing the First Amendment protections of Sullivan as just being for the media. Now the worm is turned, and they're defendants. They're individuals who are individual defendants in defamation actions, and so is Trump. And guess what? Guess what defense they're going to use? They're going to use Sullivan. They're going to use Sullivan and say, hey, we were just throwing it out there. We didn't know it was false. We had no reason to believe it was. And so they're going to be relying on the bedrock Sullivan principle in their defense, which I think is just so ironic. The other point is, but that just shows you, I mean, it shouldn't matter what side you're on. Sullivan protects all of us. It protects the speech of Trump and Giuliani and Powell and me and RonNell and Lori and any speaker who shows up and criticizes the government or a powerful person. But the second thing I want to say is, I think this is a particularly bad time to talk about reducing protections for the press. I mean, we have lost 2,000 daily newspapers in the last 20 years, leaving local news deserts across the country. We have communities that had 2 daily newspapers that have none now, several across our land, and some that are reduced to 1. And those that are still alive are barely alive. They're on life support because the disruption by the digital platforms has totally disrupted their business model. So, they're vulnerable financially. And as you see locally, I mean, the Salt Lake Tribune had to go to nonprofit, and the news staff has been drastically reduced. They don't have budgets to do the legal battles that we used to engage in for the last 20, 30 years. I mean, I think back, 10, 15 years ago, the number of access cases I would fight or subpoena battles I would fight because there was a budget for it and they cared about the principles. They're not doing that anymore. I mean, they get sued, they have to defend, but the stuff that really makes a difference in terms of open government and transparency and self-government, those lawsuits aren't getting filed, and public officials are not being held as accountable as they were because the news media is just not there in terms of its strength the way it was 20 years ago. So to talk about, now more than ever, we need the protection for local news outlets to be critical of the government, to voice the concerns of those who are critical of the government, because we have so few of them left. So, I know that Judge Silverman, he's talking about the media writ large, and I think Justice Thomas's complaints are about media bias writ large, but I look at it through the prism of a local media lawyer trying to help clients, survive and do the job of holding government accountable. And it would be unthinkable for me not to have the Sullivan protection, because I do think it deters a lot of frivolous, unmeritorious lawsuits that are so expensive to defend, and it can be ruinous for small newspapers and media outlets.
So I'm going to ask a naive question here, but could you ever contemplate a time when they would carve out individual speech versus media speech, public media speech?
It was floated at the US Supreme Court briefly in the cases that followed Sullivan. Some suggestion, it's a case called Rosenblatt, is that right, Jeff? Some suggestion that the Sullivan line of precedent really did arise and take root in the context of these kind of watchdog function media organizations, and so ought to be limited in that scope. And the court considered and rejected it on the grounds that I think our questioner was hinting at, right? Which is that that kind of accountability and watchdog functioning, although it unquestionably takes place, like the laboring oar on that is pulled by organizations that are devoted to it, because we cannot all day, every day act individually as checks on our government, right? I'm not going to send my own, I'm not going to travel to the deep south to report on the civil rights movement the way that the New York Times was going to do. And so that kind of accountability journalism is responsible for a lot of what happens in this space. But the court, as a First Amendment matter, was unwilling to distinguish between the two camps of defendants in that way. And I do think that Jeff's wider point is incredibly important here, that we are at this like confluence moment where I think we're going to have to think really critically about the role of the law in general and of constitutional doctrine in particular in the preservation of the press and the press function in democracy. And just in part because of changing legal norms, but also just because of changing factual norms, these news deserts, the changing media landscape, the shifting advertising dynamic, this sort of series of crises that are facing the operation of the press function. And we're not going to forever have something that might be readily identifiable as the institutional legacy press that we had at the time that Sullivan emerged, but we're always going to have the performance of the press function. There is a thing that we do that is important, and news gathering, and particularly accountability journalism of the sort that was at this sort of centerpiece of Sullivan, not only is going to keep happening, but has to keep happening if we're going to operate a democratic republic in the way that the Constitution structurally presupposes.
Okay, we have another question. Doesn't common carriage regulation of social media platforms implicate First Amendment concerns? When the DC Circuit upheld the FCC's net neutrality rules, it dealt with arguments that the rules violated ISP's First Amendment rights by saying that common carriage protects the reasonable expectations of consumers who were advertised neutral end-to-end conduits, and that the rules would not apply to ISPs that told customers up front that they had offered edited/filtered services. social media companies all have terms of service that lets users know that they curate and edit content at their discretion. And I've noticed sometimes on my Twitter feed, it will come up and say, this tweet was removed, or because it violated content or whatever. So the original question, doesn't common carriage regulation of social media platforms implicate First Amendment concerns?
Yeah, Jeff, do you want to take the lead on it, or do you want me to?
You go ahead, RonNell.
Yeah, so the questioner is tapping into the precise theme that I think that Jeff was trying to highlight for us, and the precise kind of pot that Justice Thomas is stirring here, which is this question about the public-private divide and the way that we constitutionally conceptualize of these massive platforms that control sort of our new public space, right? The space in which we all speak to each other. So if we used to think of the First Amendment as being a really useful tool for us because it provided for the free flow of information on matters of public concern in the literal kind of town square that we all shared with each other. And now Thomas is rightly highlighting, I mean, Thomas was not the first person, not anything close to the first person to sort of start this conversation about what we do about the sort of massive monopolistic control that some organizations might have over the conversations that we have about matters of public concern, if it's where all the dialogue happens. And a piece of that question is whether the old public-private divide and the old the First Amendment applies to the government, and the First Amendment does not. The First Amendment applies to the government's regulation of private entities, and the First Amendment does not apply to public and to private entities, a speech regulation of other users of their platforms through these terms and conditions. People are pushing at those boundaries now. People are, plenty of folks are sort of asking that we step a few steps back and reconsider the whole framework, reconsider whether First Amendment limitations that we might, of course we otherwise would have seen be the case. It is of course the case under current doctrine as it presently exists that Twitter has its own First Amendment rights, right? It has a First Amendment right to say, just like I do, right? You can't come onto my lawn and speak, and I'm not violating your First Amendment rights. The government is violating my First Amendment rights if it forces me to let you on to my lawn to do your speech. And so, foundational questions about whether that should remain the case, whether we should conceive of public and private spaces in the same way that we have, is part of what's happening here. And I think there are going to be some much more foundational debates about the space in which, about the scope and space of the First Amendment's applicability. And I think Thomas's position in some respects is surprising to me. It's surprising to me that Thomas and a number of folks in what I've otherwise thought of as a quite libertarian space are super eager at this moment to advance regulatory control over these spaces in the name of a sort of new brand of libertarianism, right? Of speech-based private spaces. And so I think it's we're on the cusp of a really interesting debate and dialogue in that dynamic.
So isn't it? So I'm going to say the standard, typical law school answer, once you start down this road, aren't you stepping on the slippery slope? Once you start trying to have that critical question about public versus private, applying public rules to private companies and entities, when we haven't changed their character from a private company into a common carriage, don't we step on the slippery slope in all kinds of ways?
Yeah, I mean, there are scholars who have now proposed the sort of full-blown application of what we might think of as like state action doctrine to Facebook and Twitter and other major platforms that control the space, in part because Congress, through giving Section 230 immunity to these entities, has sort of opened up their capacity to operate in the ways that they do, and because Congress's pressure may well be pushing them to engage in some of the content regulation that they're engaging in. So Congress is sort of, the argument is that, you know, Congress is carrot and sticking the social media platforms to get them to engage in regulation of speech that Congress itself couldn't do directly under the First Amendment, and therefore there's some arguments that they ought to be treated as state actors when the private companies engage in this regulation. But Lori's right that whenever you open the door to conversations about expanding or contracting constitutional applicability, there are massive questions about the doctrinal contours, why we would expand the doctrine, what sort of underlying values are served here, what risks accompany the expansion of the doctrine, what benefits accompany it, how to cabin the doctrine once we do, right? Because we can't think ahead to what all of our media climate will look like in the future. I think all of those questions are squarely on deck, and having a justice of the Supreme Court start to make nods to them, even solo in concurrences from denial of certiorari, spurs the conversation more.
So Jeff, that just means your practice is going to explode.
Yeah, it's I get a number of clients that call me up and say, someone posted something defamatory about me on Facebook, help me take it down. And it's like, it's almost impossible. I mean, you can do what you can to drive down the results. You can go through their system of trying to file a complaint about it, but you know, it has real world consequences. And of course, Facebook isn't responsible. They're not regarded as the publisher of the statement because of the Section 230 immunity that RonNell's talking about. But yeah, I mean, it just constantly evolves. But you know, in one sense, the technology has changed, but I don't know that necessarily that means that the legal principles should. And I know that's what Justice Thomas and all these scholars are suggesting, but I think a few years ago in the case, I forget the name of it, RonNell, where the Supreme Court was considering a situation where a sexual predator had to register on a registry. Yeah, they talked that the same, you know, the internet, the First Amendment applies to internet speech on the internet in the same way it applies in more traditional forms of media. So I don't know. I'm concerned as a practitioner about just upending all the rules that have been so valuable in terms of protecting speech and the press and the function of the press to hold government accountable just because the technology has changed. Although I recognize that social media has become a sewer. I don't know what the answer to that is. I'm not sure it's more government regulation.
Well, thank you both so much. I mean, this is absolutely fascinating. We all hear about these cases all over the news and social media, and you sort of don't know where they're going and why. So I really appreciate this explanation and the food for thought you've given us where we will go in the future. So thank you both so much. And thanks to all of you who are able to attend today. We will get you your CLE certificate, and this will be posted on the law school's YouTube page probably within the week. So thank you, and I hope you all have a good weekend.